to our mid-year labor law update from the California Employers Association. It's already been quite a year, and I'm sure a lot of you have a lot of concerns. We're very excited to have experts with us today to talk to you about what's going on. First of all, we have Virginia Young, who is the HR Compliance Director at the California Employers Association, where she tracks and reports on the new employment laws, regulations, and cases that impact California employers, among many of her other roles. I didn't want to put down her whole bio. With over 25 years of experience advising and defending employers across the state, she's a trusted resource for practical compliance strategies and real-world HR guidance. Joining her today are Anna Manzano and Juliana Gabriel. They're going to be supporting her through the chat. So when you have questions, if you put them in the chat, they will either answer you with responses or they will put links. So I'm going to highly encourage you at the very end to save the chat. If you don't know how to do that, you will go to your chat window and you would click at the very top, and it's set, and you click the three little dots, and then you just hit save chat, and it saves it in a Zoom folder on your computer. And then people asked about, there will be a recording of this after next week. We will have it up on our YouTube channel, and we can, when we put it up and we notify you, we can have a copy of the PowerPoint as well. And with that, I just want to say we're in excellent hands today. So please join me in welcoming Virginia and Juliana and Anna, who's going to tell you everything they possibly can about the middle of 2025 and what's going on in the labor and employment.
Thanks, Nancy. It's hard to believe we're over halfway through 2025, and it's been a really busy year so far with a lot of news at the federal level. For the next close to an hour, we will talk about get you up to speed on what's happened, where we are now, and what to look for in the coming months. Nancy introduced us already. We are CEA. I'm very sorry about the advancing the slide issue here. Give me 1 second. We are CEA, and we are an employers association and human resource consulting company. We are not a law firm. I'm having just a little bit of trouble advancing my slide, although I did not in the practice session, which is odd. Okay, there we go. We are not a law firm, and this presentation should not be relied on as legal advice. If you do have an issue of legal significance to yourself or your company, you should consult your counsel. A brief agenda today. We're going to start at the federal level, talk about a lot of the executive orders and employer impacts relating to those. Then we will move to some California wage and hour updates, talk about some new cases and regulations applicable to California employers that you should know about, and end with some summer reminders for all California employers. So let's get started with what's going on at the federal level. They have topped the news since January with increased immigration enforcement and the multitude of executive orders issued by the president at the forefront. So we're going to talk about I-9 compliance as it relates to immigration enforcement, and then we're going to move into a discussion of executive orders and their DEI or diversity, equity, and inclusion implications for employers. So let's start with the I-9s. Brief refresher, federal law requires all employers to verify that all their newly hired employees are who they say they are and have legal authorization to work in the U.S. Every employee hired since November 6th, 1986 has been required to complete an I-9 form at the time of hire. This form is also an important safeguard for employers because if the form is not, there can be, complete very severe penalties if an employer knowingly hires someone who's not authorized to work in the U.S., and filling out the form completely and in a timely manner provides a safeguard to the employer for those issues. Although the I-9 is not filed with any agency, employers have to keep them on file because they could be required to present them for inspection upon notice. from the federal government. So I talked a little bit about timing requirements for I-9. Here's a little pop quiz to start us off. You have a new employee starting work on a Monday. What is the deadline to complete their Form I-9? And you can drop your choices, your answers in the chat if you like. The first choice is A, Monday, on or before their first day of hire. Choice B, Thursday within 3 business days of hire. Or choice C, within 7 calendar days of hire. And we'll just take a second and maybe Juliana can let us know what the answers are looking like.
Yes, we have a group that's pretty on top of it. We have a lot of Bs. So they're saying within 3 business days of the hire date.
Well, that's good to know because answer B is the right answer. Remember that the I-9 has 2 sections. The first one is the employee section where the employee attests to their identity and their authorization to work. That part of the I-9 does need to be completed on the first day of hire. But the second section, the employer section, where the employer reviews in the presence of the employee their documentation and documents that it looks to be facially valid, that has to occur within 3 business days of the hire date. So sounds like you're all on top of the timing for your I-9 forms. There is a new I-9 form that was released in 2020. It has a form version date of January 20th, 2025, and an expiration date of May 31st, 2027. These are not major changes to the I-9 form. The last time the I-9 form was really overhauled was in 2023, and that was the change that changed the I-9 form to a single-sided sheet that contains both sections 1 and 2, made it fillable to be completed on tablets and mobile devices, and moved a lot of the previous additional sections for preparers and translators and for re-verification and rehire situations to separate supplements. These changes were really added to reflect some of the goals of the current administration. For example, the word alien, non-citizen has been changed to alien. The word gender has been changed to sex. Otherwise, not a lot of huge changes. Employers often ask when they should start using the new I-9 form, and the answer is right away. It always makes sense to do it right away. However, you are allowed to use another I-9 form version until it expires. And there are currently 2 I-9 forms other than the most current one. They are both dated 8/1/23. One has an expiration date at the end of July 26, and the other has an expiration date of the end of May 27. And you can still use those other forms until they expire, but I think it always makes sense and is a best practice to just get up to speed with the new form as soon as it's released. Another question we frequently get is whether a new form means that an employer should correct or replace I-9s of existing employees solely because there is a new form. The answer is no. As long as the version that you used to complete the I-9 form was not expired at the time it was filled out, you should not update I-9 forms or attempt to re-verify employees based on a new form version. Re-verification, when it's not required by law, can lead to unfair immigration practice concerns. So, so if your I-9s were done under a form that was current when you did the I-9, then you can leave them as is. You do not need to update. One thing we have been talking about a lot this year is remote verification. Generally, the way the I-9 process is intended is for the documentation review to be in the employee's physical presence, where the employer or their authorized representative is in the same room face-to-face with the employee looking at their documents. That physical presence requirement was relaxed during COVID, and remote verification via Zoom, for example, was allowed. But the relaxation of the physical presence rule has ended. And now the only employers who may do their I-9 verification remotely are those who participate in the E-Verify program in good standing. So if you are not an E-Verify employer, it's important to remember that either you or your employee or your authorized representative need to be physically present with the employee to verify the I-9. If authorized representatives include, in California, either licensed attorneys or registered and bonded immigration consultants, registered and bonded with the state of California. Otherwise, if the person is not an employee, it's not an appropriate authorized representative for you. California expressly prohibits the use of notaries public to do I-9 verifications unless they are also a registered and bonded immigration consultant or licensed attorney. If you are an E-Verify employer and you are continuing to take advantage of remote verification, you should remember that there are some requirements. You have to have a live video meeting with the employee. They have to provide you with their documents in advance and show them to you during the live video interaction. And you are required to retain copies of those documents. So keep in mind, make sure your I-9, your process for doing your verifications is appropriate depending on whether you are an E-Verify employer or not. We do recommend that employers audit their I-9 forms, and this is because it is an opportunity to correct errors before the government finds them, which shows good faith. It's also an opportunity to discard I-9 forms once you have passed the record retention period, leaving fewer I-9 forms for the government to inspect. And also, and probably most importantly, this is your opportunity to correct errors. And to do this, you draw a line through the incorrect information, enter the correct information, initial and date. Additionally, you should prepare a written explanation for the correction, why it was made, sign and date that explanation, and attach it to the I-9 form. Never backdate, never use whiteout. That creates more of a problem, most likely, than the error in the first place. So correcting I-9 forms every year, if you correct them every year, again, it shows good faith, and eventually it makes your process better, of course. So California has some additional requirements relating to I-9 inspections that all California employers need to be aware of. As an employer, you may receive a notice of inspection from the federal government requesting your I-9 forms, and you will typically have 72 hours to provide those to the federal government. But the moment you receive that notice, you are required under California law to provide notice of the inspection to your employees within 72 hours. So there is a form that the Labor Commissioner has developed for this purpose that you can use, but it does need to be posted within that 72-hour time period. And if your employees have a union representative, the union representative also needs to receive that notice. So California law has this first notice requirement, and then there is a second notice requirement as the inspection goes on. If you, as the employer, become aware of any government findings that an employee potentially lacks authorization to work in the U.S. or has potential document deficiencies, you have an additional duty to provide that employee notice of these findings within 72 hours of your receipt of them. So very important to remember, your obligations don't end. Your obligations are not only to the federal government when you get one of these notices of inspection, you have these additional notice obligations to your employees. And this year we've been getting a lot of questions about what happens when ICE comes to the workplace, when they knock on our door. This is happening more and more. And sometimes employers don't quite know what they have to allow ICE to do and what they can say. Some general rules to remember: You may refuse ICE to enter any non-public areas of your workplace unless they have a valid warrant. So ICE has the right to come to any public areas of your workplace, just like any other member of the public. But unless they have a warrant, you do not have to allow them into non-public areas. So you'll of course want to read the warrant, make sure you understand where it is they are permitted to go with the warrant. But you don't have to allow access to an area that is not open to the public and not covered by the warrant. It's also important to remember that your workers do have the right to remain silent in the event ICE comes to the workplace. They can't be required to speak to ICE. So just a quick summary, make sure your process for completing timely I-9s is in place, audit your forms annually, and make sure you're aware of California's unique requirements relating to inspections. CEA does have a self-audit toolkit that can be helpful, but it's a good idea to get that audit process in place on a regular basis. So that's, we could talk for hours about I-9 and ICE-related issues, but another important development where there's been a lot of news on the federal side is the DEI and the executive orders. And just DEI programs, first appeared in the 80s and 90s, and were becoming very popular, particularly after 2020, gaining a lot of steam. But 2025 has seen a cultural shift away from DEI programs. One cause of this is likely a couple of executive orders that have been issued in the early days of the new administration. And these executive orders were generally arguably aimed at ending DEI programs, both in the federal government and the private sector. A lot of businesses have rolled back or eliminated their DEI programs in response to these executive orders. But let's talk a little bit today about two of the key DEI-related executive orders and what they mean for California employers. The first one we want to talk about is Executive Order 14173, ending illegal discrimination and restoring merit-based opportunity. This executive order basically targets what is called illegal DEI. And the executive order takes the position that there are certain DEI programs that violate anti-discrimination laws because they establish preferences that result in employment decisions being made on protected classes or based on protected classes. For example, a preference to hire someone because they are a member of a particular racial minority would be an example of what this, what the executive order is describing as illegal DEI. But it is well established that making employment decisions based on protected categories is illegal. That is not a new law or a new interpretation of existing law, but it is a signal of increased enforcement by the federal government where a DEI program is viewed to cross the line of having employment decisions that are based on protected categories. And in furtherance of this emphasis on enforcement, the executive order requires the Attorney General to provide a list of recommendations of high-profile civil compliance investigations where the government suspects this type of, quote, illegal DEI. That list was supposed to be done within 90 days of the executive order. That date came and passed in May. I don't think it's been made publicly. It's not public knowledge, as far as I know, whether that list has been made and what it says. But those were the instructions to the Attorney General in the executive order. If you were a federal contractor or subcontractor, the executive order had some immediate effect on you because it revoked affirmative action requirements that have applied to federal contractors and first-tier subcontractors since the 1960s. These requirements were put in place for affirmative action for women and minorities in the 1960s by an executive order, but this executive order in 2025 did away with those requirements. There are still affirmative action related requirements for contractors relating to veterans and individuals with disabilities that are still in place. So to answer the question that we often get is, does this executive order make DEI illegal? The answer is no. It's a misconception that only minority employees are protected under the law, but the type of illegal DEI, making decisions based on protected classes, has always been illegal, and this executive order doesn't change that. It is, the executive order is intended to signal increased enforcement in DEI programs that, do create these preferences where, minorities may be favored over the majority group, because those kinds of decisions are still based on a protected class. In fact, the Supreme Court recently held that courts cannot impose a higher burden of proof on a member of a majority class who brings a discrimination claim than they would on a member of a minority group. So I think that the case was a woman who was heterosexual brought a claim of discrimination when a gay man was hired in her place. And the circuit court, this was in a different part of the country, but they placed a higher standard of proof on her because she was a member of a majority group, being heterosexual. And there was a division between the circuit courts relating to this issue and what standard of proof should be applied in these reverse discrimination kind of cases. And the Supreme Court very recently in the last month held that the standard of proof has to be the same across the board, regardless of whether the complainant is from the majority or the minority group. We are likely to see increased enforcement at the federal level against the large companies and nonprofits who maintain DEI programs where they feel that this kind of discrimination is taking place. This executive order is subject to a lot of litigation, but is currently enforceable. So I think it is important to keep abreast of developments, but it does not necessarily change the existing law relating to DEI. So just a quick reminder on that, well, not a quick reminder, but what are best practices? It's not unlawful to maintain a diverse and inclusive workforce. You have to be careful about giving preferential treatment based on a protected class. Examples of things that can get you in trouble with your DEI program would be things like quotas, awarding points for applicants of certain protected classes or minority groups. There are some exceptions for veterans' preferences in certain instances of government employment. And one thing that people don't often think of is that employee affinity groups are often limited to people who are a part of whatever group it is, a women's group or a Black attorneys group or something like that. Making membership in those kinds of groups dependent on being a member of the protected class can also raise issues. So you should be mindful of that if you have these kinds of employee membership groups at your workplace. The best way to get in front of all this is to make sure your documents about what your criteria are, what skills and experience that you want for a job position, have those drafted and in place before you make the hiring and promotion decisions that may later be called into question. The second executive order that we want to bring to your attention is Executive Order 14168. This is the Defending Women from Gender Ideology Extremism. and restoring biological truth to the federal government executive order. It's an extremely long title. Generally, it states that the government recognizes only male and female as sexes and defines sex as an immutable biological classification, essentially rejecting the concept of gender identity. Along these lines, we've seen a lot of changes at the federal level to their forms, requiring individuals to identify as either male or female. We've seen this on things like passport applications, immigration forms, EEOC complaint intake forms. And if you're large enough to have to do a EEO1 report, you will probably realize that starting this year, employers could no longer report non-binary employees as a separate category on this report. But like the other executive order, this one does not change existing law. It does, and in particular, it does not change an existing U.S. Supreme Court decision from 2020, which held that Title VII's prohibition on discrimination because of sex includes sexual orientation and transgender status. So just by way of background, many state laws expressly protect these categories, including California, but Title VII does not expressly mention sexual orientation or transgender status or gender identity, but the Supreme Court case determined that the protections against discrimination because of sex encompassed both of these concepts. The executive order expresses the administration's wish that this decision not be interpreted to extend to the right for access to single-sex spaces such as bathrooms based on gender identity. So there's a lot of language to that effect there. As I mentioned, many states, including California, expressly protect sexual orientation, gender identity, and gender expression. California is one of them, our Fair Employment and Housing Act. And California's Fair Employment and Housing Act regulations require that employees have a right to use a restroom or locker room that corresponds to their gender identity and to be addressed by the name and pronouns associated with their gender identity. So this seems a little bit at odds with the language of the executive order. Is it in conflict with California law? Possibly. It could develop in a way that there is a conflict between, if federal law develops along the lines that the executive order would like, there could be a conflict that arises. But as of now, California's protections are simply broader than those that the executive order believes exist under federal law. So this is another one to keep an eye on. General DEI to-do list takeaway is to just keep an eye on your hiring and internal promotion policies to make sure no preferential treatment is occurring. I mentioned drafting the objective job criteria in advance, training your managers and recruiters so that they understand what the important aspects of the job are so that they're asking the right questions and looking for the right skills. And of course, as I've said about 4 times, continue monitoring federal developments and the pending litigation. So we will move away from the federal government developments and news for the last few months and turn to some California wage and hour updates that we are seeing this summer. There are some local minimum wage increases on July 1st, some industry-specific minimum wage increases. There is a new meal and rest break waiver case issued by a court in the last couple of months that we want to talk to you about. And we also want to circle back and remind employers of recommended wage and hour audit practices in light of recent amendments to PAGA in 2024. So just a refresher, the minimum wage in California is $16.50 an hour. This translates, if you have exempt administrators, executive or professionals, Paid on a salaried basis, this hourly minimum wage translates to a minimum salary of $68,640 a year. Many localities in California, over 40, have local minimum wages in excess of the state minimum wage. And many of those do their annual increases on July 1st and not January 1st. So depending on where your employees physically perform work, they may be covered by a local minimum wage requirement. And that minimum wage requirement likely increases every year, and that it could be one of the July increases. So you'll want to make sure you're aware of where your employees are physically working. Even if they work at home and they don't work at your physical office, they're going to be governed by the local minimum wage where they perform their work. CEA keeps track of most local minimum wage increases at this bit.ly link here. It's always a good idea to go to the local government website where your business is or where your employee is performing work to make sure you understand what the requirements are. We often get the question whether the higher local minimum wage affects that exempt salary that I mentioned on the previous slide, and the answer is no. The state minimum wage drives the exempt salary minimum, not the local minimum wage. So that's some good news. California has the state minimum wage of $16.50, but there are also a couple of industries that have different state minimum wages. One of them is the fast food industry. Employers who are covered by that law include limited service restaurants that are part of a chain with over 60 locations nationally. And they have their own state minimum wage, which is $20 an hour and has been $20 an hour since April 1st, 2024. Because this is a state minimum wage, it affects the exempt minimum, the exempt salary minimum, which translates to $83,200 a year at that $20 an hour rate. So if you do have employees, if you are covered by the fast food minimum wage law, you'll want to keep apprised of what the Fast Food Council is doing. They do have the ability to raise the fast food minimum wage every year. There has not been an increase announced in 2025. However, there has been some reporting that there has been a push for an increase to $20.70 an hour. So as of today, there's not a meeting of the Fast Food Council on schedule, but it should keep your eyes on it because they are the ones with the authority to adjust that fast food minimum wage. The other industry with a statewide minimum wage is the healthcare industry. That has a very complex tiered system. Certain kinds of facilities have different minimum wages. They went into effect in October 2024, and the minimum wages ranged from $18 to $23 an hour, depending on what type of facility it was. There is an increase there was, I guess, on July 1st that covers most healthcare facilities. Specifically, hospitals and large integrated health systems moved from $23 to $24 an hour on July 1st. And there is a new supplemental wage poster relating to the healthcare minimum wage. If you do have questions about whether you're covered by the healthcare minimum wage law or which tier of minimum wages apply to you, the Labor Commissioner has an excellent set of frequently asked questions at this bit.ly link that can help guide you through the most common questions there. And again, because this is a state minimum wage, the exempt salary is affected by it. And the rule for the healthcare industry minimum wage is that to be exempt, the employee has to be paid 1.5 times the healthcare minimum wage, or twice California's minimum wage, whichever is greater. So again, a different standard for determining exempt salary minimums. Okay. So I mentioned that there was a new court case about meal breaks, and we're always thankful for those because the meal breaks are a very technical area in California that drive a lot of employers crazy. And we rarely get guidance from the courts on exactly what the requirements mean that are written in the statute. But we did get one this summer, and it relates to meal break waivers for employees who work whose total workday is no more than 6 hours. So quick refresher, a non-exempt employee who works over 5 hours a day is entitled to a 30-minute unpaid meal break. However, they can waive this meal break if their total day is no more than 6 hours and the employer mutually agree to waive the meal break. If an employee, a non-exempt employee again, works over 10 hours, they get a second unpaid meal break of 30 minutes. But if their workday is no more than 12 hours and they took their first meal break, they can do a similar waiver of their second meal break, again, with mutual agreement with the employer. We have employers often ask if they can just give all their new hires a form at the beginning of employment where they waive their meal period for all work shifts of 6 hours or less. Is this okay? It makes it a whole lot more convenient for everyone because most of the time employees want to waive that meal period and go home earlier. And who's going to get, it's a pain to get a meal break waiver from everybody every day. So luckily, the appellate court in California held that it is okay to make advance written meal break waivers for all work days of 6 hours or less. The advance waivers have to be in writing, knowing and voluntary, expressly revocable at any time by the employee, and there cannot be, the waiver has to promise no retaliation, and there has to be no retaliation in practice if an employee refuses to sign or revokes their meal break waiver. This is a really helpful decision, just solidifying, a practice that just makes a lot of business sense for employers. The best practices are to make sure that, the terms of your waiver are very clear and the right to revoke is very clear and explained to the employees before they sign. And training supervisors never to pressure employees about these waivers is really important. The court took note that in reaching its decision, there was no evidence that the employee was coerced into signing it or that there was any kind of pressure or retaliatory action for revocations. And the court specifically stated that if there were such evidence, it would have serious reservations about upholding a waiver. So it's a helpful case. It's great to have this practice. Just make sure that in practice, the practice of asking employees to sign the waivers and allowing them to revoke is done properly. Okay, and lastly, I mentioned, you've probably heard that last year, the Private Attorney General's Act, the statute that allows employees to bring lawsuits, representative lawsuits, against employers to recover penalties on behalf of a big group of employees for labor code violations. And these lawsuits, of course, carry attorney's fees and are extremely popular. There are a lot of complaints about PAGA because the cases would involve, just horrendous penalties. Once you multiply them, every pay period for 50 employees adds up really quickly. So there was some PAGA reform in 2024 that allows employers to reduce their penalties by demonstrating that they took reasonable steps to comply with wage and hour laws. And it is really helpful because employers who take these reasonable steps can cap their penalties at 15% if they take all the reasonable steps before they receive a PAGA notice or employee request for records. So what are these reasonable steps? You have to conduct periodic payroll audits and take action on the results. You have to have lawful written policies relating to your wage and hour practices, meal and rest breaks, overtime, no off the clock work, things like that. You have to have evidence that you train your supervisors on how to comply with your policies and the laws relating to wage and hour. And if you have a supervisor who is not complying, you have to demonstrate, that you take corrective action in that situation. So, it's really important to take advantage of this opportunity to reduce PAGA liability, because so many employers are affected by PAGA notices. If you have a PAGA notice already, these reforms can still help you, because there are steps you can take even after receiving a notice that can also limit your penalties, just not quite as low as the 15% as may exist for employers who took the steps before they got the notice. If you do have a PAGA notice, you should be consulting with legal counsel immediately before taking any action, so you can have a plan as to how to respond. So just a brief summary on our wage and hour discussion. You've got some minimum wages going up in local areas, as well as the healthcare industry is recently seen a wage increase. Make sure you're aware of those and are complying with them, including your exempt salaries if needed. Take a look at your meal period waiver practices. Make sure that if you are using advanced meal period waivers, make sure that they meet the requirements outlined by the Court of Appeal, and that your supervisors are not, know that they are, there cannot be any retaliation or pressure if employees don't want to sign the waiver or if they want to revoke it. And again, take a look at those reasonable steps to protect yourself in the event of PAGA litigation. CEA does have a number of materials that can help you with wage and hour audits, including a PAGA prevention package that can be helpful in this process. So there have also been some developments in employee rights and protections. The first half of this year, we'll talk about the California Civil Rights Department. They have approved artificial intelligence regulations that will take effect in October that we'll talk about. There's been a new case about reasonable accommodation of disabilities that we will go over. And then we have a few labor law poster and notice updates that we want to remind you of. So let's start with the artificial intelligence regulations. Basically, the Civil Rights Department, the CRD, has issued regulations that deal with automated decision-making systems that can include artificial intelligence, as well as other types of automated programming that influences employment decisions. Examples of automated decision-making systems, or ADS, can include things like resume screeners, automated interviewing scoring systems that may make predictive assessments could be included, video software that analyzes facial expressions, tools that prioritize, automated tools for prioritizing candidates or directing job ads to certain groups. These can all be covered by these new regulations. And the gist of the regulations is really that the Fair Employment and Housing Act applies to AI, just like it would to anything else. In addition, if discrimination is caused by AI, both the employer and the person who sells the AI can be liable. Often AI tools result in what is called adverse impact discrimination, meaning that the employer did not intend to use the tool to discriminate against a certain protected class, but that was the result of the AI. Something in the other way, the AI or ADS tool resulted in an adverse impact or a disproportionate adverse impact based on a protected category. So it's important to note, you may have heard the term adverse impact mentioned in the news recently, and that's because the President Trump issued another executive order in April instructing the EEOC to deprioritize discrimination actions that are based on adverse impact theories as opposed to intentional discrimination. So that is the federal stance on enforcement of anti-discrimination laws, but that doesn't mean that that anything has changed with respect to the fact that adverse impact discrimination is still a violation of the Title VII and of California law, and these regulations, you know, I guess help point out that AI can result in this kind of discrimination that an employer can ultimately be liable for. The other thing the regulations point out, they make it clear that artificial intelligence is not enough for the individualized assessment that is required when an employer is deciding to not hire or revoke an offer to an applicant based on a criminal record. As you may recall, California law for a number of years has required employers to go through an individualized assessment if they're going to revoke an offer based on criminal conviction history. And these regs make clear that that has to be done by a human being. AI alone is not going to be sufficient to meet that statutory requirement. And finally, these new regulations do require record retention of AI-related records 4 years from the date they were created or the personnel action involved, whichever comes later. So it's important, again, they're not effective until October 1st, but important to make sure you're aware of them and take a look at your processes before they go into effect. I mentioned that there was a case recently about reasonable accommodation. This is another area where we don't get a lot of guidance from the courts, probably because cases don't get that far. But in this case, this is a situation that many employers have experienced. Is they had an employee, he was injured at work, unable to work. He exhausted his FMLA, CFRA, 12 weeks of family medical leave. He still wasn't medically able to return, so the employer continued to grant requests for extension of his medical leave as an accommodation of his continued disability under the Fair Accommodation of a Disability under the Fair Employment and Housing Act, or ADA. The employer granted multiple leave requests, and on the fourth leave request, which came in about extension request, I should say, which came at about a year into the leave, the employer reached out to the employee and, with a questionnaire that said, is there any other of these accommodations that could possibly help you get back to work? And the employee responded that he didn't want any accommodation other than leave, and that he did not know when he would be able to return to work. The employer decided to terminate the employee. And as you might imagine, the employee filed a lawsuit, but the court ruled, I believe on summary judgment, in favor of the employer, highlighting that, the request for leave was indefinite, and that the employer's good faith efforts in engaging in an interactive process with the employee by granting repeated requests for extensions, reaching out to the employee to explore other accommodations, were enough to show that they did not violate their duty to engage in the interactive process and provide reasonable accommodations to the employee. The important thing to remember about this case is that it affirms that the employer does not have an obligation to grant indefinite leave with no expected end date. But it also, its emphasis on the particular facts of the case and the employer's behavior and the employee's responses really sets out that there's no bright line rule for the duration of unpaid leave as an accommodation. The employee in this case requested indefinite leave, but the result might have been different if his request had been more definite. And the result might have been different if the employer hadn't reached out to explore other accommodations with the employee, fully engaging in the interactive process. So it's just a little bit of a roadmap to what the employer did right in this case. So it's good to see the court agree that the employer took the right steps in this case. But it is always advisable to consult counsel in those kinds of situations because they're very fact specific. Finally, on the employee rights issue, we do have a couple of posters and notices that you need to be aware of. In particular, there is a new California crime victim notice. The California Civil Rights Department published this notice on June 30th, and it needs to be distributed immediately to new hires, annually to all employees, and anytime the employer is on notice that the employee or their family member may be a crime victim entitled to these rights. So if you may recall that the California crime victim statute was revised and amended significantly on January 1st of 2025. And this is just the notice coming out 6 months later that you need to get out to your employees. But now it's hot off the presses as of June 30th. So that should be an immediate to do. Again, we talked about the minimum wage postings. The EEOC is revising its federal Know Your Rights anti-discrimination poster to try to bring it in line with the executive orders that we discussed, but that has not been completed yet, something to keep an eye on. So I won't go over the to-do list since we're short on time, but it'll be there in the slides if you want to take a look at it. Just a couple quick summer reminders before we wrap up here. And I will go into those right away. California has a indoor heat, Cal OSHA has an indoor heat illness standard. It went into effect last summer. And just a reminder that it requires employers of indoor places of employment to have heat illness prevention standards, including a written heat illness prevention plan. The requirements of things that employers have to do are triggered when the indoor temperature exceeds 82 degrees while employees are present. It technically applies to all indoor places of employment. It's really aimed at places where there's no full air conditioning, but all employers need to be aware of the requirement for a plan. And in general, the requirements are similar in a lot of ways to the outdoor employment heat illness standards, access to water, free water, you can't make them pay for it, cool down areas where the temperature is lower than 82 degrees, emergency response procedures in the event of heat illness. And when the heat gets higher, 87 degrees or 82 degrees, but the employee is wearing restricted clothing or near a high heat radiant source like an oven, there are some additional requirements that you want to be aware of. Let's see, you have to do training for your supervisors on the heat illness program, which I mentioned before. And some of the additional requirements when there is high heat include monitoring and recording the temperature and the heat index regularly, additional increased monitoring of new employees for their response to the heat, and basically trying to cool your workplace down through engineering or administrative controls, such as getting more cooling if you can, or rearranging schedules or things like that to keep people out of the heat. Workplace violence prevention, as you may remember, the workplace violence prevention standard went into effect last summer. It does require annual training. So if you got your workplace violence prevention plan in place right when you were supposed to last summer, now is time for annual training. This includes a review of your workplace violence prevention program and soliciting employee feedback, as well as analyzing the periodic hazard inspections that you've done over the year, and input from safety meetings. So this is an annual requirement once you get the plan in place. So make sure you have that on your calendar. And lastly, most people, CalSavers is a California retirement plan for employers who don't have employees who don't have retirement plans at work. All employers are required, and kind of a phased in approach, depending on how many employees they have, to either register with CalSavers or determine that they were exempt because of their existing retirement plan. But the deadline for everybody to have made this determination whether or not they need to register with CalSavers is coming up at the end of this year. So if you haven't done that already, now is the time for that. Just a summary, make sure you're aware of your violence prevention and heat illness and CalSavers deadlines. CEA does have some safety partners if you need help with any of these safety related issues. And what's next? Make sure you stay up to date on your trainings. A lot of these, like the workplace violence prevention, come up regularly, including mandatory harassment prevention training, which is every 2 years, and the supervisor wage and hour training. We recommend keeping your handbook current and making sure your posters are current. And it's important to follow the news because labor and employment law develops quickly. There are lots of sources. We hope you'll follow our blog because we try to keep our members as informed as quickly as possible of these changes. So you can sign up for that. If you are interested in CEA membership, here's just a quick breakdown of our different membership tiers. And since we are short on time, I won't go into the details, but I do want to thank the Greater San Fernando Valley Chamber of Commerce for having us today. We do have a quick survey. We appreciate your input on our presentation today, and you can take our survey at the QR code here. I'm going to leave this up for about 30 seconds, and then I'm going to flip to a slide that will give you your training codes if you have taken this, if you have attended this webinar for HRCI or SHRM credit. I will put those codes up in a minute, maybe less than a minute, and then I will go ahead and turn it back to Nancy. And thank you, Nancy, for having us today.
You. Well, I'm also so glad that you offer the training codes, because that's often a question that we get asked. And so thank you so much to everyone from CEA for presenting today. There's a lot of information here. I mean, even as a chamber, we try and get you information as quick as we can. And if it wasn't for organizations like CEA and some of our other members that are in employment law area, I don't know how we would keep up. And if you are a member of the chamber, you should have received a free poster, employment poster at the beginning of the year. We partner with CA on that, and thank you to our member Russell Lookadu at H Architecture, who's on here, for sponsoring that. We provide one a year to our members for free. If you're not a member, you can still purchase them, and if you're on this call today, you can purchase them at our member rate if you do not have a 2025 poster. And you heard there's updates to it, but a lot of them you could get yourself. So I'm going to put that in the chat along with our tariff workshop coming up. And other than that, if there's no more questions, I want to thank Virginia for such a great workshop today, and Juliana and Anna for monitoring that